Hello, viewers. My name is Richard Land. I'm a Connecticut-based attorney and a member of the Danbury, Westport, and Southbury, Connecticut law firm, Chipman, Mizuko, Emerson. As an attorney, I devote all my time and energy to estate planning, estate settlement, and trust administration. Including me, our estate planning and trust and estates department has 8 attorneys who devote practically all their time and energy to dealing with issues related to trusts, wills, taxation, elder law, and all related issues such as powers of attorney, living wills, and conservatorships. In addition, we have 4 probate paralegals and other staff. You put it all together, it's about 15 people devoted to the estate planning and trust and estates practice areas. My goal in this video is to help you identify the things that happen around you that should make you think a will review or an estate planning review is a very good idea. There's a lot of change that goes on all around us. My job in this video is to help you identify the things that happen around you that should make you think a will review or an estate planning review is a very good idea. So that's my job, to help you identify when a review might be very important. First, we have lots of tools we offer without charge to help you. Also, we have what I think is the niftiest thing we've ever done online, which is our online estate plan review. The way this works is the process takes you through a series of questions. It's a decision tree. It identifies issues for you. It's not going to answer legal questions for you, but it's going to identify questions that may be really important for you to look at in order to achieve the goals that you want to achieve in your estate plan. This is a customized process. It's customized to your particular facts. At the end of the interview, we prepare a memo for you that outlines all the many things you may need to think about when you review your plan. To give you an idea of what you'll receive, here's a quick look at a sample. I believe this is at least a $600 value, and you can take it without charge just because we want you to be better informed about what it takes to make certain your estate plan will actually work as you would like it to. So now that I've finished with the introduction, let's start the presentation. The question is, why should you review your estate plan? I've listed some reasons here. There's an opportunity to correct mistakes. We're all human. Even lawyers make mistakes. So there may be a mistake in your plan. It doesn't hurt to look at it periodically just to make sure that everything's the way it should be. Also, clients can make mistakes. When we do an estate plan for our clients, we give them all sorts of information about how to do beneficiary designations for life insurance policies, how to change the ownership of their assets, whether joint accounts are a good thing in their case or not so good a thing. A lot of suggestions on transfer on death accounts, Intrust for accounts, and similar arrangements. And many clients don't take those instructions to heart, or they forget, or their busy lives distract them from thinking about such things. They sign their documents, they leave our office, and that's the last time they think about that kind of business. But it's important to take care of that kind of thing because your plan won't work properly if you ignore it. Keep in mind that your non-probate assets, your life insurance with a beneficiary designation, jointly owned property with rights of survivorship, those types of arrangements, are not controlled by your will. And of course, your will is where all your important instructions are going to be. So, if you don't have beneficiary designations properly set, and if you have all your property owned jointly with rights of survivorship, your will won't have any relevance at all. So it's important to fix that kind of mistake. It's also important to take into account that the law has changed. In the recent past, at the state level, we've had law changes that relate to powers of attorney. We've had law changes that relate to living wills and healthcare instructions. We've had law changes that relate to probate court reform. We've had law changes that relate to the administration of trusts. At the federal level, there have been a lot of very important tax law changes. I'll talk about that later. The point is that in the recent past, there have been lots of law changes that can have an impact on how your estate planning documents should be prepared. Because these changes seem to come along in a fast and furious way, you really need to be alert. If you're not frequently focusing on all the things going on that may affect your estate plan, you should calendar a review every 3 to 5 years. It's not just law changes that you need to worry about. There are changes in the circumstances in your own personal life. Think of how much has happened in your personal life. If you're anything like me, lots of things have changed. Everybody's life changes. It all seems kind of normal and mundane, perhaps. But these life changes can have a big impact on the goals that you want to achieve in your estate plan. And there may have been changes in the lives of your beneficiaries. You watch your kids grow up from infants to toddlers, and then they grow up and they have their own kids, and then they get into financial trouble or their marriages fall apart. These are all things that should make you think about, well, there's that plan I did 10 years ago. Is it still a proper plan? Your documents name people who you're counting on to carry out the instructions that are in your will. That's your executor, your trustees, and the guardians of your children. Maybe you named them many years ago, but their lives have changed. You discover that the guy you thought was a very solid citizen 10 years ago wasn't so solid after all. He's been involved in a scandal. He's had financial troubles and enormous debt. He's got addictions. His life is a mess. But you've named him as your executor and trustee in your estate planning documents. Maybe it's time to consider a change. These types of things can happen to the people you name as your executor, trustees, and guardians, and to your agent under your power of attorney. And your estate plan is only as good as the people who you name to carry out your instructions. So that's a very important thing to think about. And then there are changes in technology that can change the way you think about your estate plan. For example, recently we were introduced to a service that helps manage assets for those people who are frail and maybe need some help with their finances. It's called TrueLink. It is, in effect, a debit card that can be used by caregivers subject to limitations in amounts and types of expenditures. You can find out more at this link at truelinksfinancial.com. So there are all sorts of things to think about. I'd like to spend some more time talking about properly handling your non-probate assets because mishandling them is a real problem that destroys a lot of estate plans. Here are the most common types: jointly owned property, entrust for accounts, transfer on death accounts, life insurance, and retirement plan accounts. Here's an example, a very simple example, of a young parent with a child. At this point in this young single mother's life, there's not much in the way of assets, just $350,000 consisting mostly of life insurance. But whatever she has, she knows my child's too young to receive an inheritance in that amount. I can't let that happen. And even if my baby were 18 years old, I couldn't let that happen. That's too young. I want trust management. So she does her will to arrange for a trust so that the assets would be managed for the child by a trustee. But she forgets to change her life insurance beneficiary to make that work. She forgets that, back when she first bought the life insurance, she named her child as a beneficiary. Her lawyer had told her to change the beneficiary to make certain that the life insurance proceeds would be paid to the trust for her child, but she forgets to change the beneficiary after she does her will. So what does that mean? Well, what it means is all the life insurance death benefit, which is a large part of what this client has, will go outright to the child, not to the trust. Exactly the opposite of what she wanted. The terms of the will don't control the life insurance. Rather, the beneficiary form for the life insurance policy is what counts. She needs to change the life insurance beneficiary designation so that the will controls it. And typically, that would mean paying the proceeds to her estate so that the will could then send it to the trust, or preparing the beneficiary designation form so that death benefit is payable directly to the trust. So that's the type of thing that people need to think about when naming beneficiaries of life insurance policies. Let's talk about entrust for accounts and joint accounts. Sometimes people will have the goal of benefiting all the children in equal shares, but then, for some reason, and it usually happens because they're not getting such great advice from a banker, they'll go to the banker and they'll say, "I'm afraid of getting above the FDIC insurance limits." And then the bank will say, "Well, why don't you try an Intrust for account, because for insurance purposes, that's handled a little bit differently." And before you know it, they have an Intrust for account that names one of the children as a beneficiary of an account, forgetting that doing so can disrupt the whole estate plan if the goal is to treat all the children equally. So instead of treating all the children equally, one child, in this case Jim, gets an account while the others do not. Jim will get more just because of that one simple careless mistake. People don't understand that naming beneficiaries in this way is really an estate planning decision. It favors one child over the others, and it can affect the final result in a way that's contrary to the overall intention. Another good example of beneficiary designation mistakes has to do with retirement plan accounts. The tax rules on the disposition of retirement plan accounts at the owner's death have changed. When I talk about a retirement plan account here, I'm going to refer to RPA. RPA for retirement plan account. It's easier to say. Under old rules, before 2020, if you set the RPA up properly, at your death, your beneficiaries could get the benefit of a very long deferral based on the life expectancy of the beneficiary. For example, if the beneficiary were 35 years old, the RPA deferral period could be around 48 years. If the beneficiary were 50 years old, the deferral period could be around 34 years. That's a very long period of tax deferral. That means that for the 50-year-old beneficiary, the beneficiary could take 1/34, or about 3%, of the account in the first year after the owner's death, and the rest of the RPA, that's 97%, could stay in the tax-deferred account until the next year, when about 1/33, or about another 3%, of the RPA would be paid out, and so on until the beneficiary of the RPA passes away. If you did it wrong, the full balance of the RPA would have to be paid out in 5 years. That's a huge difference. A 34-year deferral period versus a 5-year deferral period. 34 years of tax deferral can be a very valuable thing. A short period of 5 years can be very costly. Lots of times, when the RPA owner is married, the RPA owner will name his spouse as the beneficiary if his spouse survives him. The spouse is a special beneficiary who has even more favorable rules as a beneficiary, but we won't get into that right now. Right now, I want to focus on what happens if the spouse does not survive. So sometimes the RPA beneficiary designation names the spouse as a beneficiary if the spouse survives him, but does not designate a beneficiary if the spouse does not survive him. In other words, there is no secondary beneficiary, which in many cases means the RPA will be paid to the RPA owner's estate. So if I have an RPA and my spouse is a beneficiary, but there's no secondary beneficiary, if my spouse predeceases me, then what happens? Well, the RPA gets paid to the estate. In that case, the whole RPA must be paid out in 5 years. The 5-year rule applies if there is no designated beneficiary. That can be a really hefty income tax bill to pay in a short 5-year period of time. But if the 50-year-old child were the beneficiary, the RPA could have been paid out over the child's life expectancy, or 34 years. The point is, that could be a big mistake. It's just important to pay attention to these things and know that they have ramifications, maybe more than you might imagine. Before we leave this topic, I want you to know about a tax law change that applies to retirement plan accounts. After 2019, in most cases, the longest deferral that a non-spouse RPA designated beneficiary can get is 10 years. So the 34-year deferral period I just described has been reduced to a maximum of 10 years. Nevertheless, a 10-year deferral is better than a 5-year deferral, and it would be a mistake to fail to name a beneficiary and end up with the 5-year rule. When naming beneficiaries for RPAs, if you have young children and you're thinking about young children as a beneficiary, you might be thinking about, well, it's not a good idea to have a youngster as the beneficiary of such a large account. Maybe at my death, the RPA should be paid to a trust for the benefit of my young child. Well, you have to be very careful about the way those trusts are drafted, because if they're not drafted in the way suggested by the regulations, which are very complicated, vague, and uncertain, then you've got a problem. You could very easily end up with the 5-year rule instead of the 10-year rule, or even a better rule that might apply to a trust for a young beneficiary. That's the end of part 1 of this presentation. Thank you for viewing. We hope this information is helpful. In our next part, part 2, we'll continue to discuss common mistakes that can be corrected when you review your estate plan. We'll discuss inappropriate reliance on simple wills, failure to adequately consider executors, trustees, and guardians, and failure to adequately prepare for cash needs, including taxes. To continue, please go to part 2. Thank you.